Hello, my friend. On today's episode, I'm joined once again by the always insightful Cory Sterling, who's the founder of Conscious Counsel. We're talking about all things legal today, but don't worry, Cory really has this kind of magical way of making legal things sound approachable and even fun. We walk through some of the biggest legal issues facing gym owners today, including things like employee misclassification, non-solicitations, media releases, and the new click-to-cancel rules. So if you ever wondered whether your contracts are solid, whether your waivers are doing their job, or your staff is classified correctly, this episode is a must listen for you. Grab a notepad and let's dive in. Hello, fitness business nerds. What's up? Welcome to another episode of the Business for Unicorns podcast. I'm very excited for today's episode because we're having back on the podcast again for the first time since 2023. I had to look it up. Mr. Cory Sterling. Welcome back to the podcast, Cory.
Thank you, Michael. Thanks for having me. And I just want to give a big shout out to Unicorn Society and all the nerds out there. I'm a nerd myself, so I feel right at home and it's great to be back. Thank you.
Yeah, welcome back to the Nerdum. For those of you who weren't listening to the podcast in 2023 or somehow missed it, Cory is the founder of a place called Conscious Counsel that provides legal counsel for creative, ambitious business owners who are building communities to make the world a better place. I love that mission. So, Cory, just say a little bit more about what do you do at Conscious Counsel?
We're a law firm and we work with health and wellness professionals, predominantly boutique fitness studio owners and we essentially make law fun for them. And we have really streamlined, simple legal solutions. I started Conscious Counsel 8 years ago, and I've worked with more than 1,500 clients. So lots of experience of working in law and understanding what gym owners and boutique fitness studio owners need when it comes to being legally protected, and just love sharing information and coming up with creative, simple legal solutions.
Yeah, I love that. And it's so needed because I'll just speak from my own experience for a second, not only as an owner of multiple small businesses, but also just as a coach who's trying to help small business owners on a daily basis. One of the places where my help and support ends abruptly is when it comes to legal matters. Right? That the minute we get to legal stuff, I can share some experiences of my own and share what I've heard other people do, but they really need a professional who knows the law in their area. And so I'm so grateful to have people like you who are making all that legal stuff accessible, maybe even a little bit fun, dare I say. And so I just appreciate your work so much. I know we've sent you some folks in the past, and I hope more people listening to this call when they have legal issues will come to you because I know you all work with such great integrity. So thanks again for doing this podcast.
That's very kind of you, and it would be awesome in the gym owner report card to have a legal section on there as well, and just have a question. Hey, are you using customized specific industry specific legal documents? Because you're right, this is something that not a lot of people know about, and the more that I do it and the more people I help, the more I realize that no one teaches this basic information. And it's not a gym owner's fault that they don't know the difference between an independent contractor and employee or what needs to be included in a waiver. But that's really, I decided to focus on one thing in my life, in my professional life, and I'm on a mission to transform legal services for heart-leading health and wellness professionals. So we're here now, and I want to share all the information that I've got.
You're doing it, my friends. Well, I just made a note of that. I would love to. We'll circle back after the podcast and talk about the things we can add to some of our materials that are legal oriented. I love that idea. But let's just start with the basics, which are what are the basics, right? So for all the gym owners out there who are thinking for the first time, well, damn, I've never spoken to a lawyer, or I got all my materials by Googling them. What are some of the core materials and things that gym owners should be thinking about that they should have on hand? You mentioned a few already. Knowing the difference between different employment statuses, waivers, liability waivers. So what's a kind of your top hits here for things gym owners should be considering?
Yeah, if we look at a legal package, the typical legal package that we would set a gym owner up with, and I'll just take one step back, and the really easy and fun game to play is think about the different relationships you have in your business as a gym owner. And the goal is for each relationship, you want to communicate expectations openly and honestly. You want to communicate these expectations in a signed, legally binding agreement. And you want this agreement to be specific to your business and at best legal practices. So to make something that seems overwhelming and stressful really, really simple, it's like, cool, who do I do business with and what needs to be in that contract for that particular relationship? And so typically when we break it down, gym owners have relationships online. So you need a privacy policy for personal information that you collect. You would need a social media disclaimer for any information, tips, tricks, teaching that you put on social media. You'd need a media release for any photos or images or videos that you use of your clients, or maybe that clients share with you. Next comes to liability. So waiver of liability is the big one there. It has to be specific to all the activities that you offer and the specific equipment that you have. You obviously have a relationship with your members. So either that's a membership agreement or a service agreement. They're really the same thing. A membership is a type of one. And that just, outlines refund policies and click to cancel, new laws that have come into effect. You look at your team. Are they contractors? Are they employees? Do we have an employee handbook? Does it outline all of the different situations that might come up? And then you'd think about your brand and protecting your brand with a trademark, and protecting your intellectual property if you've got training manuals with copyright. So that's sort of a 30,000-foot view of all of the most of the different things that we see come up for gym owners and the different relationships they have.
Yeah, I think it's a great list, Cory. And I love that you start with just the foundation of who are you in relationship with and how could you negotiate really clear expectations on both ends? Because I think, at least in my experience, and tell me if you agree here, so many lawsuits come out of missed expectations, right? Where one person thought X was going to be the case, another person thought Y was going to be the case. And then that creates a conflict that turns into a lawsuit. So the more you can be clear upfront and in writing, what the parameters are of each relationship, the less likely, you're not going to get rid of the possibility of a lawsuit, but the less likely it is, someone's going to come after you for that confusion. Is that a fair way to state it?
Yeah, you've got it, Michael. And one thing I'm very proud about it in my career is that from all the agreements that I've drafted for clients, none of my clients using an agreement that we drafted for them has ever gotten sued.
Amazing.
And I think that one of the main reasons for that is because before someone works with someone, they just tell them, hey, like, this is the expectation. Or before someone accepts a client at their gym, hey, this is the expectation, and read through it. And then if that other person breaks the agreement, it's really reasonable. Like reasonable is a big word in law. That's like boring law. But to make it fun, it's really reasonable to be like, hey, before we allowed you to be a member at our gym, this is what you agreed to do, and you're not doing it. So how can we restore integrity to this relationship, or how do you want to move forward? And when you can show someone that, it's very, very powerful. It's not ego, it's not right, it's not wrong. It's like, hey, this is what we said we were going to do, and you're not keeping your end, and it's not making you wrong, but how can we rectify the situation?
Yeah, I love that. That's a great way of thinking about it. All right, well, I want to go through, if it's okay with you, I'm going to go through kind of the top hitters I see of the issues that gym owners bring to us and me and my coaching team, and just kind of maybe somewhat rapid fire go through kind of what your hot take is, as rapid as or not as it can be. But the first one, actually, you mentioned on the onset, which is I see a ton of gym owners and frankly small business owners as a whole miscategorizing their employees as contractors, and so I think this is probably a pandemic, forgive the expression, in the fitness industry, of so many people being treated as 1099 contractors when they really are being treated like employees. Can you just kind of break down the big picture difference and why this matters so much to get it right?
Yeah, it matters because if you misclassify, the worker will have legal leverage over you. And I've been through many situations with studios where the studio or the gym has tried to fire someone, and they've come back and said, well, actually, you called me a contractor for 7 years, but you were treating me like an employee. So this is what I want my exit package to look like. I swear to God, I've seen that numerous times. So at law, you always want to be in control of the situation. So why does it matter? One is you lose control of the situation if you misclassify. Second, there is a very serious risk of getting audited by a governmental organization, whether on the state or the federal level, with the IRS or the CRA in Canada, and they're looking for it. In the fitness industry, it's somewhere where they come after, because they know that fitness professionals aren't paying attention to this. And I have 3 clients who've unfortunately lost their business because they misclassified the workers. So it's very, very
Yep.
serious, because what they do is you'll get audited. They'll ask to see the contract. They'll want to understand the working relationship. And then they'll say, okay, well, you've misclassified and you've been in business since 2012. So now it's 13 years of back pay taxes plus interest on those taxes. And then you get a bill for, you know, hundreds of thousands of dollars that you're not able to find your way out of. So that's the second reason it matters. And then third, I think, is just ethical reasons, in the sense that government has put in rules to say if you're going to treat someone in a certain way, you got to make them an employee. And
Yes.
I'm not saying anyone's taking advantage of anyone, but if you're a person who follows the rules and believes in a society that's built on the rule of law, then there would be ethical considerations for not
Yeah.
following this. Is that helpful?
Yep, that's a great list, Cory. And I'll say, just from my own experience at Mark Fisher Fitness, we were audited, and this is one of the things that the auditors came to first. One of the first things they dug into was this distinction, and in part, I think, because it is so commonly, and we got through that with flying colors, thankfully. But it's because we were thoughtful about how everyone was classified, and our contracts were in place that were the right ones for the right people. And so I think that's a really important one. And I think if anyone listening who's like, oh crap, I don't think my people are classified right, I don't know the distinction, great, go email Cory. It's time to get your house in order in that way. Yeah. All right.
Hey there, Business for Unicorns podcast listeners. If you haven't had a chance yet to leave us a rating and a review on whatever platform you listen to this podcast, it would be so awesome if you take just a quick second to do that. And here's why. Number one, by leaving us a rating and review, you'll allow our podcast audience to grow so more gym owners can build a life and a gym they love. And number two, by leaving us feedback, you'll help us shape the future of the podcast so we know what you like, we know what you don't like, and we know what types of content is resonating and what else should we create for you. Thank you so much for your consideration. And now back to the show.
Right. Yeah. All right. Let me go on to the next one. The next thing, the next two actually on my list of things that people come to us about are both about clients. I'm sorry, I meant employees, both about employees. The first one is actually about whether or not well, I'll do this one first, about people, employees who need accommodation, about employees who are struggling with a mental health issue, some sort of illness, some sort of problem at home, some sort of personal issue. And in the US, the phrase that we often hear tossed around is that employers are required to make some reasonable accommodations for folks when they have some sort of, disability or limiting ability. And so what's your kind of hot take here? What's your hot advice here? Because this comes up all the time in conversations with our coaching clients.
Yeah, it's really interesting, and I've had a bit of work of this even just in 2025 of supporting clients where someone had to leave because of a surgery and then came back and then had challenges. And
Yes.
the big, I mean, look, it's going to be a lot of the times it's going to be state specific when it
Mm-hmm.
relates to the level of accommodation that you have to provide, what the reasonableness of that accommodation is. Like with anything, it's about managing the relationship with the people that you work with and having
Yes.
a great team culture where there's an open space for people to communicate, and where you also, as the business owner, are able to communicate in a way that you feel comfortable with. A lot of states will also have at will termination. And so
Mm-hmm.
essentially, you can terminate an employee without giving any particular reason. And so, because the audience who's listening are mostly gym owners or studio owners, I would just be very careful about what you put in writing when anything comes in around someone mentioning something or feeling that they're being treated differently. Because I actually had two situations at the same time. One where a client reached out to me as it was happening, and I was like, do not put anything in writing. This is the process that we're going to follow, and this is how we're going to terminate the working relationship, because the person was making problems and looking for unreasonable accommodation. And what we
Yep.
see often is that workers, whether contractors or employees, will try to take advantage. Some will. There are certain bad apples in every batch. And so in that situation, I said, let me deal with it. We can terminate this the right way without putting anything in writing. And the person was the employee was fishing, was like trying to provoke
Mm,
the gym owner into saying certain things so that they would have a
of
discrimination
course.
case against them. Conversely, I had another client who was also trying to get rid of someone, where they brought me in near the end, right when a legal problem was coming. And I was like, send me all of the communications. And there were some communications that did not support my client's position, which made it very, very
Yeah.
difficult. So as a general rule, be careful about what you put in writing. And as a comment, this is an issue that I think will just become more pervasive in the industry.
Yeah, I think you're right. I think you're right. All right. Well, I think that's a super great high level overview of that. Well, let me go to the next one here. The next one is also about staff members, and this one I think it comes up a ton in our industry. I'm sure you have a lot to say about this, which is non-compete and non-solicitation agreements. I know the laws have also in some places have changed on this recently. So what's your latest take on this?
Probably the biggest issue that I see studio owners and gym owners dealing with is non-competes and non-solicitations. Okay, non-compete is going to be very, very, for a 1099, it's not happening. There's no way.
Yep.
It's completely contradictory towards a contractor relationship to say you can't work with anyone else. For an employee, if they're not earning, more than six figures, and they're not working that many hours for you, it's just a non-compete's out the window. Non-solicitations are enforceable, but are very, very tricky. The situation that I've seen happen often is that a gym will have a trainer, and the trainer will be there for a couple of years and have all of the members' social media accounts. They leave and they post a message, "Hello world, I'm starting my own studio and this is where it is." And then
Yep.
it's, is that solicitation? Legally, it's very difficult to prove that. I'll just zoom out and say the two practical tips you need to know is, one, you need to have non-solicitation provisions in all of your agreements. Having a non-compete in that's unenforceable may hurt you, but that's only if things really go further down the line. But way more importantly, it's a culture thing. It's really a culture thing with your team and how you communicate with them. And, if they want to move on, are you supportive of that, and how so? Because anytime I've seen this be a real problem, there was some form of personal vendetta or
Mm-hmm.
a personal relationship that was tarnished, and someone said something wrong, and then that's how it came about. So it's just culture, 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 culture.
Yeah. Well, I love that you pushed so hard on this, Cory, because I think, we both have had this experience where, no one wants to get to a lawsuit. Even the lawyer is saying, don't let it get to that point. Focus on building strong, positive relationships, a culture that really makes it clear, that we're keeping lines of communication open, that we're here to support one another. Because if people are talking and they're in dialogue and they're in conversation and they're supporting one another, you're not going to get to the place where you need to worry about the legal stuff. But I think, the minute communication starts to break down and feelings get hurt and the lines of communication start closing, then people turn to a legal solution. So I just love that you keep pushing in that direction, which is build strong, mutually beneficial relationships, keep the communication and culture in a positive place, and you'll have to worry about all of this less. That being said, let me circle back to maybe my fourth hot topic, and you mentioned this one earlier, which is click to cancel. So some rules have changed somewhat recently about our consumers' ability to cancel memberships for gyms. So just kind of talk through what's happened.
Yeah, and it's not surprising, because as there's just been a shift in society of so much recurring memberships and so many things online, and it consumer protections will always drag a little bit behind, but eventually catch up with the way that society operates. And in essence, there's a series of rules that now anyone who is accepting recurring revenue or has a subscription model needs to follow certain legal steps in order to make sure that someone has an adequate and legally fair opportunity to release themselves from anything that they've agreed to pay for in the future. We've seen some clients struggle with it and lose money until they've made the adaptation to new agreements that are fitted to adapt to the new laws. And it's tricky because a lot of business owners, again, don't know about this, and it's great, that you're able to share this information with your community. But essentially, there are certain things that need to be in your contract and need to be in the subscription process that give people an adequate opportunity to opt out. And what I care about is, obviously my clients are gym owners, so I want to see them win and I want to see them keep all of the money. You need to revise your membership agreement so that if someone chooses to cancel when you may not have expected them to, that you would be compensated adequately. So the system has to be designed a little bit differently now than it was before, with the intention to make sure that you're being reasonably you're being reasonably compensated for the services that you offer, and that if someone breaks a contract early, that there would be a penalty that would make sure that you were paid as much as you should have been paid.
Yeah, that makes a ton of sense. And I think, that's very much in line what I think the best practices have always been. I think now it's just, I think, a little bit more kind of, legally urgent and required for you to actually have those things in place. So, I think that's super useful for our listeners to hear. So what we've covered so far is the difference between contractors and employees. We talked about, the need to make reasonable accommodations for employees who are having, some issues, some issues. We talked about non-complete non-solicitation. We talked about click to cancel. Those are the top ones I hear on a regular basis. Anything else that we should talk about that's not on that list?
I think the big thing that I deal with the most are trademark issues.
Yep.
It's sort of it's unspoken again. What I think the general misconception is that the public doesn't know that there are trademark rules and trademark legislation, and that it doesn't operate by logic. So a lot of people will say, "Oh, I was using it first," but what matters is who registered first. So I've seen a couple of clients lose their entire brand in a short period of time, in a heartbreaking fashion, when all that would have been required would be the proactive step to trademark their intellectual property. And I think the other thing that I see coming up also is just media releases and use of media, and not authorized, and you don't have legal permission to use a photo of someone, or someone takes a photo for you and you use it and you don't have the rights to share it, and you're doing so legally. And it's so ubiquitous, photo sharing, photo posting. Think about the amount of content that every studio produces on a weekly basis. And no one talks about these issues. For me as a lawyer, my inbox is very, very full, having to resolve these issues. And so that's really why I preach an attitude of proactivity around them.
Yeah, it's so smart. I'll say, just by sharing my own experience at Mark Fisher Fitness back in the day, we had a blog, a very popular blog that Mark would write, and we had images on there that weren't ours, Getty images, other images, and they all came for us one day. Those little robots trolling the internet found their image and came for us. We had to pay a shit ton of money just to get them off our back, and of course take down the photos. But we had to learn that lesson the hard way, to not to use images that didn't belong to us. And I think there's a lot of folks out there who are continuing to use images that don't belong to them. So I think that's a really important one. All right. Well, we can keep going all day. I'm sure there's even a longer list of things we can talk about that our listeners should be thoughtful of. And I'm sure I'll have you back on the podcast again, Cory. But for now, for folks who want to come talk to you, work with you, learn more, how do they find you?
Yeah, well, I'm super happy for all the unicorns out there to offer a free consult. So we're going to include a link to that in the show notes.
Great.
And as well, following us on Instagram is always good, at Conscious Counsel. We're always sharing different posts and updates with information about what we're up to and how to stay legally protected.
I love that. That's so great. We'll include all those notes down below. And again, just, thank you so much, Cory, for the work you're doing. I think this legal stuff can be scary for gym owners like me and so many of our listeners. So the fact that you're doing it with a lot of heart and a lot of integrity just means a lot to me and to this industry. So thank you for doing the great work you're doing. And listeners, go find Cory. Go work with him. He's here to help.
Thank you very much,
Awesome.
Michael.
Yeah, of course. Thanks again, my friend. I'll hopefully see you back on another one soon. Have a good day.
Thank you.